Other side inform ಮಾಡಿದ್ದೀರಾ?
What is he saying? Just tell him 2 minutes. In 1 hour with them. Can I make a request, my lord? One matter after vacations, my lord.
Which one?
Nearly a public interest has been filed, my lord, where a status quo has been granted. Nearly 162 houses have been built for slum dwellers, my lord. And we are not able to give water and electricity because there is a status quo order. Any date convenient to your lordship after vacation?
Which is that?
It's not on the list, my lord. I'm requesting for listing of a matter after vacation. Any date convenient to your lordship?
But date is given.
No date has been
No
given.
date given.
Just for any date.
If urgent, then 15, otherwise 20. 23rd or 15, choose.
15.
15.
Yes.
My lord, when the matter will be posted at 2:30, there is a change interim order required. There are chances of dispossessing the applicant. There is the chances of dispossessing the applicant.
What is disposal?
This is in respect of land acquisition, my lord.
Land acquisition.
Please,
No, not to move the learner vacation.
Please, kindly permit me to move in a vacation.
You file and to be listed. Press matters are always listed. You file in the vacation and listed.
Number 36 and 37 and 38. Office objections is there.
Serial number?
36, 37 and 38, my lord. Their office objection, my lord. We are filing a translation copy.
36, 37, 38.
Amit M. Megde.
The office objections in all the aforesaid appeals shall be removed within 3 weeks, failing which the appeals shall stand automatically dismissed without reference to or order of report. Then till number 28 to 35. Same order, but 4 weeks. Same order. Instead of 3 weeks, 4 weeks.
My lord, serial number 44, my lords. I appear for the respondent.
Yes.
My lord, I request your lordship to post this matter at 2:30, my lordship. Date was given in this matter for today. Date was fixed for today, my lordship. It was
2:30
not
can't.
listed today.
2:30 can't. Either move learner vacation judge or after vacation.
Date was given for today, my lordship.
Then you should have mentioned yesterday. Today it will not be posted. On the same day we are not posting.
Great.
So when do you want to reopen it? 16th of January.
15th of
16th January.
16th.
My lord, serial number 44, my lords. I appear for the respondent. I've not been.
I pay for the appellant, my lord.
Yes.
I pay for the appellant. They want a copy of the writ appeal, madam. I will provide today itself, my lord.
So when?
Any date, my lord, any date.
Any date, my lords.
Any date, then 4th March.
Okay.
Much obliged.
Your Honor.
Request of learner parties and order.
Fresh matter, Your Honor. Fresh matter for posting. A contempt petition is being filed. The order of the Honorable High Court had given the respondent
It
direction.
will be listed after vacation. Why do you worry? No memo is necessary. On the last day,
One submission, Your Honor. The order passed by the High Court was to comply by 12th of June. Sufficient time was granted to the respondent, but since they are not done, my renewal license is pending.
perhaps see that is listed after vacation, soon after.
Number is listed.
No need to give me.
Number
Be
just
listed.
give the number.
Give the number listed.
My lord, serial number 34, my lord. Office objection is there, press time.
We already said 4 weeks or 3 weeks. Not 34 is said. 1 second. 34 is false. 28 to 35. We have said. 4 weeks.
Obliged,
Otherwise, we will automatically dismiss.
obliged.
Right?
Any mention through VC, sir? Grant permission. So list 1, contempt matter, serial number 1,
Mr. Janardhan ji,
Notice returnable on 4th March.
seal number 2.
Notice returnable on 4th March. Notice.
Seal number 3. Mr. K. R. Ganesh Rao.
Notice returnable on 4th March.
Notice issued. Seal number. Next date.
4th March.
Seal number 4. Obliged. Mr. Shiv Prasad Shantan Gowda.
Same notice.
My lord, any shorter date, my lord. Any
Shorter date. 17th February.
Much of it. Seal number 5. Mr. Karthik V.
Same 4th March.
Seal number 6. For compromise.
The lordships kindly recollect. Yesterday I filed the compound petitions.
Parties are present.
Filing memo.
Parties are present. This is the memo they are filing in a first petition. But they are agreeing for this compromise. They have signed. The party is also present before the court. All the parties present before the court.
First petition is 36679.
My lord.
In between parties, they arrive in that memo, but they agree for the compromise in the petition of last petition, that is. In my petition. On the compromise, my lord, all the petitions may be disposed of.
You file a writ petition to recall the order passed in other petition.
Yes, my lord, in another, that is annexure B, my lord, I filed a writ petition for recalling. In government is also filed a review for that order. That is the second petition, yeah.
The prayer in this writ petition, when filed, was to set aside order dated 20th for 2017, passed by this court in writ petition number 85 to recall and set aside. Recall and set aside the order passed in writ petition number 8533 of 2017 on the ground that the order was obtained by respondent 4 fraudulently. It was further prayed to direct the respondents number 1 and 2 authority to pay sum of rupees 3,04,82,403 with which is the interest accrued on the earnest money deposit. Also, the dispute originated from auction
Yes, my lord.
proceedings, which took place on (16/8, 2008).
My lord, yes, my, in the synopsis, my lord, kindly,
16/8,
16/8/2008.
The petitioner had paid the contribution towards the deposit of earnest money, had paid the earnest deposit, had deposited the earnest money. Today, when the full stop, earnest money thereafter litigation in form of writ petition number 11321 of 11, as well as the writ petition number 853317 ensued between the parties, which ultimately led to filing of the present petition with the prayers as aforesaid. When the petition comes up for consideration, learned advocate Mr. So-and-so for the petitioner and learned advocate Mr. So-and-so for the respondent jointly stated that the parties have settled their disputes outside the court. In that regard, memo dated 28/12/2024 was produced by learned advocate petitioner, in which it is stated as in the quote the memo entirely. So, as for the settlement reflected in the memo, in the contents of the memo, the respondent number 4 has undertaken to pay rupees 52 lakhs within 10 days from the date of receipt of the amount, which is deposited by respondent number 1 and 2 with this court. It is stated that check dated 25/2/2015 has been received, drawn on State Bank of India, bearing number 444853 for the said sum. Right?
Yeah, this is a, yes.
So you are for respondent.
I am for the respondent.
You are for, she is the petitioner in first petition.
All right.
And he is also one of the party in the compromise.
Where is the compromise?
My lord, just now I passed on.
Along with the memo.
His name is Praveen Kumar.
Along with the memo, separate compilation of papers were also furnished, which is the original memorandum of compromise entered into by the parties, compromise dated 19/12/24, entered into by the parties. The said compromise is signed by the authorized signatory of the petitioner. It is number 3 from all the other parties, as well as countersigned by the learned advocates for the respective parties. Paragraph. It was stated before the court that both the sides are personally present. Yes, where are they? They are the parties. All of them.
My lord, he is
Who is the petitioner?
authorized signatory of the company in first petition, in second, third petition.
What is your good name? Shanta Kumar? What is your name?
Satya Prakash.
So what you reached a settlement?
I agree.
What is the settlement?
Yes.
What is the settlement?
I have to pay about 45 lakhs to the petitioner company.
52 lakhs.
No, 45 lakhs.
In 27261.
27261, which we had agreed to reimburse about 45
My
lakhs.
lord, I'll explain. My lord, that 55,000 rupees to be given to third petitioner, in the third petition, that is in memo. That is, he is a Praveen Kumar. 45 lakhs to the given to my company petitioner in this first, third petition. That is what.
That is.
As per the terms of settlement, rupees 45 lakhs is to be given by respondent 4 to
Given by the third respondent in my
Respondent number
petition.
3 in 27.
Money to be released by the, it's a, money is in the deposit of the High Court, my lord, in the registry. Registry has to release the money to the,
so paragraph 5 contains. go to
yes,
the-
my lord, that is paragraph 5 is that.
The settlement.
That's correct.
settlement
Paragraph 5 is a,
Memorandum of settlement reflects as an extracting the relevant part in quote paragraph 5. Yeah, it is.
paragraph 5 and
Five.
paragraph 3 also, my lord. Paragraph 3, that is to be given to us, 45,000.
3 and
45
5
lakhs.
was- All right, the. Please select it. Along with the memo only quote, then that don't write any description. And further, along with the memo, original copy of the memorandum of compromise dated so and so is produced, date 19/12/24 is produced, which is taken on record. The same is signed by the petitioner, respondent number, by represented authorized signatory of the petitioner, from response 3 and other parties who are third parties.
Yes, no, they are all
Two-
parties.
Two are the J Nandini and J.
And other parties who are third parties. Signed by the authorized signatory petitioner as well as response 3. Full stop. It is also signed by the third parties who are not parties to the petition.
Please.
Full
Please.
stop. Learned advocates for the petitioner and learned advocates 1-3 have countersigned. They have also countersigned. Paragraph. It was stated before the court that all the parties all the parties who are signatories
Yes, all the parties.
to the settlement are present before the court. They were identified by their respective learned advocates. Who will identify the parties who are not? You will identify.
Yes, my lord, respective advocates have identified.
The parties, including the third party, are identified by the advocates appearing for the parties.
And presence also may be noted, madam. Presence also may be noted. They present before the,
We have said
please.
personally present, identified. Upon being queried by the court, it was found that they were aware of the terms of the settlement. They also stated that they have entered into settlement out of their volition and without any
Any coercion or
coercion or coercion. Full stop. The memorandum of settlement is taken record. It is relevant to reproduce the contents of the memorandum settlement. Quote pura. 3 sir. Extracting the relevant part. Up to 8. The appeal, the petition stands disposed of in terms of the settlement.
please, my lord.
My lord, may I make
Office
one
will-
submission, my lord? My lord, my review petition is pending along with these writ petitions. My lord, by virtue of the order that is passed now and the order passed by my lord, in the review petition dated 19/8/2021.
We
But-
say.
That also be disposed of, my lord.
We say that you are withdrawing in.
Allowed because the amount is directed to be paid to the company. Now there is an internal arrangement between them, my lord. So my review has to be allowed.
May not be allowed as it is not disposed of in terms of this compromise.
You withdraw the petition in light of settlement. That will cure everything. In light of the citizen.
Amount is
in light of the-
deposited in the registry.
In light of the, yes,
The amount is deposited before the honorable court.
so that will say registry may release the amount.
Please,
In
Bill.
favor of the
Yeah.
petitioner.
As per respondent R
No,
three,
what-
as per 8533.
I'll explain, my lord. I am the petitioner company. It should be released to me. That is what the government says that. What we said instead of all those things, because through company, they all invested money. I have to distribute to them. Instead of that, I am getting a TDS and all. That is why, my lord, we made this arrangement to release the amount from to the third respondent who will distribute to the company and other investors. That is what we came to a conclusion.
Paid
Will be paid
to respondent number 3 million.
respondent by the
Satya
registry.
Prakash.
The amount which is deposited with the registry of this court shall be paid shall be released in favor of the third respondent
Third respondent,
after undergoing the necessary procedure, including identification,
Please.
to enable the third respondent to act in accordance with settlement and
Please.
to disperse the amount
Please,
as
Milos.
per the settlement.
Please, Milos. Please,
my
Milos.
lord.
In light of above order passed,
Please, Milos.
recording settlement from a learned advocate for the petition does not press the petition.
Please,
My
please,
lord,
Milos.
we-
Please.
As it does not, as it does not survive, except that the party shall act in accordance with settlement.
my lord,
Please,
we
Milos.
may- state may be absolved, my lord, because we have nothing to do. This is.
So in view of the withdrawal and disposal of the petition, the review petition does not serve.
Please, Milos.
Lord,
Please,
my lord,
please, Milos.
amount to be dispersed in the petition 27261 of 2020.
As per your settlement.
As per the compromise petition. As
Huh?
per the compromise.
Correct, correct.
Please.
Memos being filed in my petition, but
Il-
Doesn't matter. It will be common. It will be a
And-
common order.
Please.
So-
Both are meant.
Milos,
And
Milos,
my lord, disbursement 45 lakhs to be to the company directly, my lord. So 45 lakhs to the company in the petition, that is 276,261.
We are saying as per the settlement.
Please,
We'll-
As
I-
per the settlement.
I'll not add any word.
Please, as per
My
the.
lord, may I make one submission, ma'am? My lord, it may be observed by my lord that the state has nothing to do with
because
this.
I have indemnified.
Absolved.
It
One
was-
sentence, my lord.
How you are concerned?
My lord, because there was a direction to pay the amount to the company.
No, 8533 was to Satya Prakash, R3 Milos.
The company,
Hmm.
it was misrepresented by one of the partners and he took an order before my lord.
No,
Then
no,
there was a direction that the amount has to be paid to the company.
We'll say that the settlement before last line. The settlement is arrived at between the private parties, which does not affect in
Yes.
any way
The interest of.
the state who is
Please.
the review applicant.
Please, Milos, please.
Life.
Oblige.
Okay.
Yes, sir.
Compromise may be part of the record, my lord, part of the order.
Everything is taken on record. Don't
Please.
worry.
Because another thing, Milos, R3 and.
We'll check the order before we'll sign.
Please. Milos,
Always check
once-
the order.
Because in 27261, he is R3. In 36679, he is R4 Milos. Please, Milos.
No
please.
problem. In the compromise petition is there.
Please, Milos, please.
Long as disposed
ಎಲ್ಲ
of-
ಎಲ್ಲಾರ್ದು ಬರ್ಸಿ. ನಾನು
Withdrawal would be a problem for me, sir. As long as it's disposed of in terms of the compromise, within my memo. also.
All right, we'll now say withdrawal.
Yes,
Should be
We'll
disposed.
now, all the petition dispose of in terms of the settlement.
settlement. Please, Milos, please.
So you take signature of the present parties present,
Please, Milos.
evidencing that,
Please, Milos, please. I'll take.
and you identify the.
We'll identify.
also.
Please.
But even at the time of disbursement also, let the authorities take all the identification and everything.
Pardon?
At the time of disbursement, release of the amount, registry can take all their identification, everything.
That registry will take as per the process.
Not the interest on that amount, my lord, 2 crores, let it go to the High Court, my lord. Interest on the amount.
No, we are not commercial over here.
No, not that, my lord. We have safeguarded the amount.
You are setting a new precedent.
No, I'm sorry, I was just a lighter
Be a
moment.
good precedent, but we will not accept.
Please, Milos. Thank you. Thank you, please.
you.
Grateful, Milos.
Registry may be directed to take all their valid identity
identity cards or whatever it is. My lord, right? That is there.
Please, my lords.
My lord, it was in a lighter vein. I didn't mean to offend.
Good lighter way in the end of the vacation. Thank you. Please, my lords.
The PL matter, seal number 7, Mr. Devendrappa.
The petitioners have filed this writ petition in the nature of writ of mandamus, my lordships, in the nature of public litigation, directing the respondent authorities, my lordships, to initiate action to stop the quarry activities which has been undertaken by the respondent number 8, my lordships. The petitioners are the residents of the Gulahalli village, my lordships.
Your rival,
Pardon?
your rival of number 8.
No, my lords.
No?
They are conducting the quarry activities wherein the agricultural lands of the petitioners are there, my lordships.
No, notice written. This is last day's bonus. Last day for any notice written on 17th January, 17th February.
This green bench matter, seal number 8.
Appearing for petitioner, my lordship.
Right.
My lordship, I paid the court fee, my lord. Sorry, my lordship, by oversight, it was not paid. I paid the court fee, my lordship.
Paid.
There is
So notice returnable on.
date may, because my lordship, 2 years has been extended by the law, legislation, my lordship, which going to expire during the month of March, my lordship. Therefore, a date may kindly be fixed.
23rd January.
Much.
My lord, a copy may be given, my lord,
I-
a complete copy.
I'll recopy of this.
This is seal number 9, the Sumant L. Bharadwaj.
Lord, I appeal for petitioners council.
Notice returnable on 27th January.
7.
20 is not sent, 27. 29 January.
This is seal number 10. Mr. S. Y. Shivalji.
It is only notice,
Notice,
only notice.
similar matter lordships have already entertained and passed the notice.
Disposed of.
No, my lord had just issued
number
notice
32953.
simpliciter.
Notice returnable on
Yes, yes.
10th February.
Similar matter is posted on 7th January. 7th January, similar matter is posted.
7 January, only 7 January.
And serial number 12 also similar. 12 also similar.
Pardon?
12, serial number 12. 10 and 12, both.
Both, 10 and 12 both.
Seal number 11, Mr. Mahendra SS.
I appear for the petitioner in this matter.
That is also only demand notice.
My lord,
Lord,
40 crores are due, my lord, 40 crores.
No, it's incorrect, no? It's not the
What
party.
is correct? Your notices, I've read from your notices.
Will issue notice.
How can you say incorrect?
Will issue notice.
Your lordship may kindly see in the similar matter,
Ah.
the lordship was pleased to grant the interim order.
My lord, for 42 lakhs, 7.5 lakhs were deposited. Now this is 40 crores.
It is
It is
incorrect
asked-
submission, Lord. It is not 40 crores.
Let them deposit
Let me,
before this honorable court.
let me make a submission. The last may kindly peruse page number 35. It is 20 crores. He is making incorrect submission before the.
No, please take back your words. You're making incorrect submission.
The last may kindly peruse. The similar notice has been issued. In para 3, 2 of the order, please. Impugned notice is at lot page number 35. There the outstanding is lot 3,17,400. Page number 35, please.
$35.
35, 35.
Really? 83,000.
3,17,400
Where is that?
in page number 35 and translation is at 40, please.
page 40.
Page 4.
Page 40. Serial number 4. In serial number 4, outstanding is 3,17,400. And penalty is 20 crores. It is not 40 crores, 20 crores as submitted by the government. And in the earlier petition lot, it was 16 crores and 40 lakh was outstanding. Therefore, your lordship was pleased to direct in the earlier petition to deposit 7.5 lakh. But here it is only 3,17,000 outstanding lot. And so far as this penalty is concerned, that has been set aside by the government itself. That was the submission made on the last occasion by 4 circulars, which
In here, this case also.
same lot. There are 35 leases.
I didn't make such a submission. He's taking me by surprise.
The last occasion also made same submission. Your last.
I haven't made that submission. I had.
I am not saying that she made that submission. I made that submission on the last.
You say that.
No, you have overheard that. I am submitting. The government has withdrawn this notice by 4 circulars, which I have produced in this petition as well as in the previous petition.
I'm not aware of all.
Your lordship, that is exactly for the reason. Your lordship, may kindly peruse the order passed by this honorable court in page number 2 of the order.
Learned Advocate Mr. S.S. Mahindra for the petitioner. So while assailing the notice, demand notice dated 23rd January 2024, which is impugned in the present petition, submits that the penalty of rupees 3,17,400
That's outstanding.
is imposed for transport without permit, and that charges for
50,000.
what is that, 20 crores?
Penalty on the basis of drone survey.
And the penalty on the basis of drone survey is imposed to the tune of 20, 21, 2, 02, 13, 20, 21, 38, 221, which makes the total outstanding according to the authorities payable by the petitioner to be 20, 25, 08, 230. When it was submitted with regard to the dues claimed as above, that the figure is arrived at not only exorbitantly, but without assessment of the liability. So there was some substance. It was further submitted that the state government has issued circulars whereby the penalty is, levy of penalty is taken out. Full stop. Learned advocate further relied on order passed by this court in writ petition number 30419 of 2024 to submit that the effects of this case are akin to one involved in the said writ petition.
The same survey number, same notices, same drone survey. It is a cluster lot.
Pointed out that the survey number is same and the drone survey is also same, which has given rise to the aforesaid writ petition as well as the present challenge. In view of the above submission, there shall be notice to the respondents. Full stop. Respondents, full stop. Learned additional government advocate accepts the notice on behalf of so and so, full stop. She is directed to file reply. Full stop. As far as the interim relief is concerned, comma, the authorities are directed not to take any coercive steps against the petitioner in respect of attachment of the properties.
Attachment and in pursuance of the notice dated not 23.
Any coercive steps pursuant to the impugned notice, including the attachment. On condition, however, that the petitioner deposits 7.5 lakhs. Same.
My lord, the notice is also
But
1
here,
year
the
old. my lord.
outstanding,
20
the earlier case,
23.
in the earlier case, the outstanding was 42 lakhs. Here it is only 3 lakhs.
That count is such calculation comparison within 2 weeks from today.
Published.
So notice returnable on, make it 18th February. If the amount is not deposited as able.
Last may kindly have it on 10th February because connected
10th
matter.
February. The amount is not deposited, the interim leave shall stand automatically vacated.
4 weeks time
If for deposit 2 weeks.
for. In the earlier case also not.
Earlier क्या किया?
My lord, then 50 lakhs, my lord. 50 lakhs.
No, I am not bargaining in the court. This is not a.
Before
No,
return.
no, this is state revenue.
Here it is within 2 weeks, let us.
Obliged, my lord.
This number 13. Mr. P. Mahesh.
Petitioner, my lordship.
What?
Like, my lordship, KRS dam matter, my lordship, wherein this honorable court has already passed an order to go before the competent authority, my lordship, committee.
Committee,
Yes,
dam safety committee.
Yes, yes.
dam safety committee, my lordship. We need to go there. My lordship,
Learned advocate fairly submits, learned advocate fairly submits that
let they consider, my lordship, in view of the order passed in WP 19755 of 23.
the present petition filed under Article 6 of the Constitution. Challenge. Notice dated 20th/1/2024, issued by the competent authority of the Department of Mines and Geology, whereby the authorities have directed that the crusher unit of the petitioner situated in survey number 73/2 and 18/2 at measuring 1 acres and 20 guntas at village Nilana
Nelana Koppalu.
Kuppalu, Srirangapetta Taluka, Madhya, Mandya district shall be temporarily shut down till further orders. It is on the ground that the unit is located within the radius
No,
of
it is beyond for 20 kilometers, my lord. My unit crusher only, my lordship. I am not using blasting. I am not using blasting, my lordship. It is only a crusher which comes 20.29 kilometers from KRS dam.
Then my lord.
notice is based on the directive of the order dated 20th/1/24 passed by this court. The notice is based on the decision of the meeting of the District Task Force Committee Mining pursuant to order of this court, wherein it is decided to suspend the activities of the stone crushing units within 20 kilometers of Krishna Raj Sagar Dam. And it is decided to issue notices. It is pursuant to this that the present notice came to be issued. In course of the hearing, paragraph learned advocate for the petitioner fairly submitted that the proper remedy for the petitioner to seek ventilation of his grievance is to approach before the dam safety committee, which is functioning for the functioning in the subject. So therefore, the petition is permitted to approach the dam safety committee in respect of the grievance raised in this petition. All the grounds are open for the petition to be raised before the committee. This court has neither gone into the merits of the case of the petitioner, nor has expressed anything on merits. Full stop. If the application is filed by the petitioner before the Dam Safety Committee, it shall be duly considered by the committee in accordance with
Right.
Within some period.
preferably within
4
8
weeks.
Preferably 8 weeks.
Obliged.
Preferably within 8. The petition is disposed of in the aforesaid terms.
Writ appeal matters. Case number 14, Abhinay V.
Applying for the appellant. This is a writ appeal.
Any urgency?
No urgency, my
Yes.
lord.
Delay.
No urgency.
No urgency, then after vacation.
No, in this matter, there was a batch of writ appeals filed in this in the same subject matter. It's regarding challenging the advance probable pro rata charges.
Will issue notice.
Issue notice, yeah.
Notice returnable on 17th February.
The main matter is on 7th of March, the other batch of matters.
Then 7th March.
7th March will be taken. Much
Case number 15, state appeal.
Responding.
Delay.
My lord, there's a delay, my lord, in
Notice
260 days.
returnable on
in filing, my lord.
19th February.
This is small matter, my lords.
30th February.
This is a small matter, my lords. May not take 2 minutes, my lords.
Small matter.
Very small, my lord. Because they're daily wage workers, working for several years. They were required to bring under the Welfare Act. Welfare Act is only for their purpose. They say that they have not completed 10 years.
But
That is the
delay hurdle will have to be crossed. So little earlier if you
some
want,
earliest
Yes.
statement.
early. 3rd February.
Yes.
Also, one submission. In serial number 14, the standing counsel for BWS is Mr. Monish Kumar.
Yes.
Can I be permitted to serve the notice upon the standing
In
counsel?
addition to normal mode of service to be effected from a counsel for the appellant is permitted to serve learned advocate who appeared before learned single case.
They respond 3 and 4.
We have the respond number 3.
3 and 4.
3 and 4.
Much obliged.
Case number 16,
Madam, my lord, the
Yes,
appeal has been
Raman is still okay?
purchased because of the
Learned
union has
advocate.
preferred a writ appeal 1405 of 2024, which is already decided by this court. and
Learned
confirmed it.
advocate for the petition submits that this appeal, which is directed against the interim order, has become infectious inasmuch as the main writ petition number,
Writ appeal number 1405 of 24 decided by this court.
writ appeal,
Writ appeal, madam.
writ appeal,
Union had filed a writ appeal challenging the
Appeal
very
number.
same order.
writ appeal number 26, writ appeal number 1405 of 24.
And confirmed by the Honorable Supreme Court in
This court, as per order dated 26 September 2024, which arose out of the same order.
yes, ma'am. And confirmed in SLP Civils 26143 of 24.
Which is confirmed by the Supreme Court in SLP. SLP number 26143 of 2024, dismissed by the Honorable Supreme Court on 14/11/2020. So this is that.
Mandatory use of,
Jute.
yes, mandatory use of plastic. IJMA matter. Bunch of- yes.
so number 17, Narsimaya K.
Worship, I am for appellant. Appellant in appellant aggrieved by the order of the writ petition, filed the writ appeal. The appellant is in possession and enjoyment of the property. Additional documents as given, proof of possession till today. Several sandalwood valuable trees are grown. Since 25 years, 2021 additional documents
RTC is given, is a presumption, we are. I have applied for stay of the order of the writ petition. So here, the applicant
Right.
is a father was a grantee of the land and he has no issues. He adopted the son as a Manjunath. He died, his legal rights are came on the document, your lordship. The survey number 56/9 situated at Baisandra, 2 acres of extent of land. So since 1975, they are in cultivation and possession. And the DC and AC order has not favored and stayed in this court. In writ petition, your lordship, in page number 90 to 23, 27, I will read this fact. The deputy commissioner who certified the mutation and order of the petitioner name to be entered in the as the adopted son of the
We'll issue
Venkappa.
notice.
Venkappa had no son.
We will issue
He is
notice.
adopted.
Issue notice.
His son.
We will issue notice. Notice written.
Right. Yeah.
Stay cannot be granted.
Respondent is a taken will. So your lordship, additional documents are given, valuable trees stay to be granted.
Stay cannot be.
20 years additional RTC is given. Latest even given RTC.
Civil litigation is going on.
Yes,
So they
RSA is pending.
Stay is necessary.
Second appeal is pending in the matter.
Second appeal, sir.
Other valuable trees are there.
Even notice. is
Sandalwood
because
and cashew nut and other things.
On that day will consider. Notice
may be
returnable on 19th February.
Please.
Notice, not only notice.
May kindly consider. Stay.
Stay
The
cannot be-
position is,
Stay
I
cannot
have
be.
been position and the enjoyment of the land and
The suits are pending, Mr. Kumar. Civil suits are pending.
Still number 18, Mr. D. Basuraj.
In this case,
My
I
lord-
appear for the respondent, my lord.
I am for the petition, my lordship.
I may be
my lord-
permitted to file my statement of objections.
Delay.
Yes, my lord, I first submit. This is the dispute between the telephone.
Delay will issue notice, delay returnable on 5th March, 6th March.
Please.
Yes.
Still number 19, Mr. Abhinav Ramana.
The appellants were selected as archaks on account of, my lord, death of 2 archaks and, my lord, resignation of 1 archak. That assistant archak, they are officiating as priests. Their appointment, my lord, was challenged before the learned single judge. Now, my lord, the learned single judge, my lord, relies upon Rule 12 of the Endowment Acts and says that there should be a provision for reservation in the post for archak. And therefore, my lord, it is nullified. That, my lords, will get at page number 28, my lord, internal page 9. By relying upon Rule 12, my lord, the learned single judge would say that, my lord, there should be, my lord, application of reservation. But, my lord, this is subject to, my lord, section 58. Section 58 of the Principal Act, my lord, says all the traditions, customs of the temple will have to be seen. There is no tradition or custom, my lord, in this temple, which provides for reservation for, my lord, priests or archaks. And therefore, my lord, without having regard to the main provision, the rule is applied. Now, the entire process, my lord, has been directed to be started afresh. These people are working as, my lord, archak, priests in the temple since 2018, since the day they are appointed. Only on this ground, my lord, it is set aside.
You are permitted to participate in the press process.
Lord, but, my lord, my selection has been annulled, my lord. It cannot be annulled on this ground. My lord, there is no concept of
Notice.
reservation.
We'll see notice returnable on.
My lord, let the process be stopped for this reason, my lord.
Can be stopped. Interim relief is refused.
Lord,
Notice returnable on 10th March. Interim relief is refused.
My lord, I'll just make one submission. Sorry, my lord. My lord, the question is, my lord, whether reservation is to be applied or not.
But we are not saying a recruitment process.
My lord, it is in my place, my lord. My selection has been set aside. My lord, it is not a case where, my lord, recruitment process is challenged. My lord, my selection, I have officiated in this temple.
Then you want to granting main relief.
No, my lord, I am only seeking for stay
Oh.
of, my lord, the order of the learned single judge.
Same.
My lord, the recruitment process will be kept in abeyance
No,
depending on, my lord.
Means your selection will be treated valid during the pendency.
My lord, otherwise, my lord, if the new board comes, my lord,
Otherwise, my lord.
new persons are appointed, my lord, the writ appeal becomes infructuous, my lord. My lord, my very object of, my lord, filing an appeal is, my lord, frustrated. If, my lord, the new
That can be done.
because, my lord, now I am.
While the interim relief as prayed for is refused, it is observed that if any selection is made pursuant to the order of learned single judge, it shall remain subject to the outcome of the present petition.
Lord, my lords may not say it is refused, my lord, because, my lord, may only
Refused,
say,
however, it is stated that
Lord, because, my lord, the rule, my lord, has to be applied in consonance with the section. Lord, please see section 58 for.
that any selection will be subject to outcome.
Yes, my lord, but my lord,
They have been
not say
allowed
that
to
the
work,
interim relief is rejected, my lord. Otherwise, my lord, it will have a different connotation. All
They
that
have
my
been
lords may
allowed to
say-
work, my lord. Those who have been appointed shall continue to work as per the learned single judge's order. They have been allowed to work now.
Say it is provided that during the pendency of the petition, if any selection takes place, it shall remain subject to outcome petition.
Very well, my lord, grateful, my lord. I request, my lord, some date to be fixed in January, my lord.
On 19th February.
Selection will be subject to.
Grateful, my lord. My lord, with liberty to move, there is some urgency, my lord.
It is always there.
Yes, my lord, grateful, my lord.
So number 20, Sri Raymond.
Pass or not possible, it will go to,
My lord, senior counsel has been engaged in this matter.
there is no urgency.
My lord, kindly pass on, my lord.
No.
Humble request, my lord.
10th March,
My lord, kindly.
just not possible to pass.
My lord, at least in month of January. Date
Month
in
of January, all.
My lord, password is.
21st January.
This is number 21.
But 21, I pay for the appellant's counsel, 21 and 22.
Same.
Lord, here the question is this, I have been allotted land. The learned single judge proceeds on the basis that I have surrendered the land. This is not so. I'm still in possession of 548 acres of land, my lord. This is allotted by KADB. What would happen is, upon allotment, I'm put in possession. The rules require, my lord, that a lease cum sale deed has to be executed. Now, my lord, I can get project finance to proceed with the project only upon getting that, my lord, document in my favor, the registered document in my favor. I write a series of letter to them, make representations, meet them. They would say, you go get high-level committee approval. I get that. My lord, on 3 separate occasions, I've got it. After that, they would say, no, we will give you the land, they give you the lease, but provided you surrender some portion of the land. But this kind of a condition is imposed on me. Then again, I have gone back and forth, literally run from pillar to post. What would now happen is, I have, my lord, thereafter surrendered some portion of the land just to buy peace. But now, even in the remaining land, fault is found with me. Though, in fact, the learned single judge would go off, my lord, on a completely different point. All I'm submitting is that this is a matter that today we are requesting for. I've been in possession of the property right from, my lord, 2008. Please permit that not be disturbed, because now there is a threat of them allocating to someone else. The learned single judge has virtually given them a carte blanche and said, do what you want to do. But that is all I'm submitting. You'll also be fix it even in the first week of January. I'm ready to argue the matter. It will take a little bit of time. Please fix it at 2:30. Let there be status quo in respect to the property is all I'm submitting. There are many observations made in the learned single judge's order, my lord, which need to be pointed out to your lordship.
It is a case of, my lord, may I submit, my lord? I am.
Can I just point out?
AIDB in this case, my lord, between 1996 and 2000, my lord, 986 acres of land was allotted to the petitioner. And, my lord, in 2011, petitioner came forward and voluntarily, my lord, offered to surrender the lands that was allotted to them. Then, my lord, my lord, the offer of surrender was accepted by the board. And, my lord, part of the land has already been surrendered, my lord, by the allottee. And, my lord, now we have allotted 160 acres in favor of, my lord, the National Coast Guard Training Center. And, my lord, possession of the land was taken in the year 2017. After that only, my lord, 160 acres has been, my lord, allotted in favor of Indian Coast Guard. possession is already with us. And my lord, it cannot be said that the possession is with them because, my lord, after the dismissal or rejection of the second, my lord, request by the petitioner for extension of time, my lord, we have resumed the land. And my lord, on that basis only, this honorable court has permitted us to, my lord, make further allotments, my lord. We have made allotments. And my lord, they have filed an application, the copy of which is not served on us.
Lord, can I just point out one aspect here, which is very important? My learned friend would now say that the land is allotted to Coast Guard. Can I point out, sir?
My lord, land is, my lord, with the
The-
KIDV. And my lord, if the, my learned friend
If it is,
wants-
let my learned friend statement then be recorded that the land is still with KIDB.
Yes, yes. We
There is
have-
no difficulty then.
we
But
have-
that is not the statement made by them. My lord, totally prevaricating stances are taken by them. Learned single judge would observe this. In fact, scathing remarks are made against them. Can I point out one other aspect? Coast Guard makes an application saying, give me 160 acres. They first make an application in respect of some other village. I say, I have no objection. That is not part of my land. After I say no objection and the interim order is modified, the Coast Guard, my lord, changes the name of the village. And basis that they say, no, this is the same village. This is what the conduct of the respondents has been. KADB. Remarks are made about that, my lord, by the learned single judge. I have to point this out to your lordships in some detail. My lord, all I would submit is the KADB today, after all the remarks made by the learned single judge, if they are not preferring an appeal challenging those observations, then my lord, their stance cannot be countenanced is what I would submit. It can't be that they accept all these findings of the learned single judge.
You are in possession.
Yes. And my lord, all I'm saying today is let them not alienate it to somebody else. Today, my lord, the difficulty is I don't have a registered document in my name. Let them not alienate it. Let status quo be maintained. That's all I'm submitting.
So notice in both the petitions returnable on.
May I make one submission supporting the petition appellant herein?
Yes.
But at page 88, if your lordship sees, the order that they are saying that they have taken possession of was stayed by the single judge, my lord, as far back as in 2017 itself. We are only seeking continuation
Learned friend is appearing in the connected companion appeal.
But I'm only seeking continuation of the same order which sustained during the pendency of the.
We've had the protection of the learned single judge right through, my lord, the proceedings.
Throughout.
12th March. You are accepting the notice?
We are accepting notice, my lord. But what I want to submit is this, my lord. On 22/11/2000.
Parties will maintain status quo.
So deeply
Otherwise,
obliged.
this will become infectious.
So grateful.
During the pendency of the petition, by a paint and relief, in order to ensure that the irreversible situation does not arise for the appellant, the parties are directed to maintain status quo with regard to the subject matter land.
No, my lords, my kindly permit me to make the submission. Out of 548 acres, with permission of the, my lord, writ court, we have allotted 160 acres of land in favor of National Coast Guard for establishing a training center in 2018 only. They are in possession of 160 acres. Excluding that, my lord, any status
even that-
Subject matter land will.
Yes.
subject matter is 500.
No work has started, my lord. No work has started.
548 acres they are saying.
Lord, this is totally. Lord, I'll show your
Indian
lordships.
Coast Guard
They would
is
obtain a
party-
variation of the learned single judge's order.
ASGFDS,
Basis one village
one
and
second.
thereafter change the name of the village. That is the conduct of the respondent. I'll point it
Even that was, my lord, granted.
Notice so and so, heard learner so and so and so and so for the petitioner and learner so and senior advocate so and so assisted by. In the text of the case, the appeal deserves to be heard finally. Notice written on 12th March. Full stop. The petitioner, the appellants asserts possession of the plot.
Please.
Plot in question.
Lands, my lord.
Land in question. Full stop. In order that the in order to ensure that irreversible situation does not arise for the appellant in the event the appellant succeeds in the appeal. By a interim order, it is directed that the parties shall maintain status quo with regard to the both the parties shall maintain status quo with regard to the subject matter.
Please.
With regard to the subject, with regard to the land in dispute.
Please, so great.
160 acres has been allotted, my lord, to in
Yeah,
national.
land in dispute.
Very good.
Land and distribute, kindly see, my lord, page 43. Page 43 is the, my lord, extent of land which is mentioned there. they refer to 548 acre scheduled property, which is not, my lord, 548 acres. With permission, 160 acres has been, my lord, allotted to Indian Coast Guard. Kindly exclude that, my lord.
No, my lord, that
Indian
is my
Coast Guard-
submission.
No, no,
The whole
Indian
thing was
Coast Guard
done by mischief. We'll point it out to your lordships.
Let the Coast Guard come and say.
Please, my lord.
My lord, they
Please.
are parties, my lord, they are parties.
Therefore,
my lord.
Let them come.
Please. Grateful.
They have established, my lord, the training.
Let them come. If they want variation. Status quo applies to all.
Please.
Obliged, my lord.
Still number 23, state appeal,
Delay,
delay of 152 days, my lord.
notice returnable on 13th March.
Still number 24,
24, my lord, Advocate General appears in this matter. Request for pass over, my lord.
Pass or not pass, we'll go to.
Make one submission, my lord. There are two ISR pending. One application is new incumbent to the officer, Special Land Acquisition Officer, and CEO has to be implemented. Therefore, we made an application that IA may kindly be allowed. Present officers are in the office. There would be no impediment for that.
Lord, Mr. Advocate General, my lord.
Let it be out after, will I allow after this, 10th of February,
8 minutes.
but
10th February,
We have already complied in this matter, my lord.
now 10th February.
My
Yes,
lord,
next.
notice to R3, I'll take in the matter. my lord.
25,
In the contempt,
24,
24, notice to R3, I'll take.
Required
24.
required to be issued.
Notice hasn't been issued to R3,
Notice,
not issued.
so notice to this 1 3 returnable on which date? 10th of February.
still number 25,
My lords, I appear for the
Govindra.
complainant in this case. This is a case where I mentioned the other day, my lord, the father has not seen the child for more than 60 days. There is a consent order passed by this honorable court, my lords, my lord will find it at page number 27, which my lord was virtually confirmed by the honorable Supreme Court.
So will you see notice?
My lords, notice, my lords, was issued, and also, my lords, it was intimated to the accused. Both occasion, copy was also served. There is no representation.
Service of notice is awaited, in that we put up next.
My lords, may I make one submission, my lords, for a moment, page number 29, my lords, for a moment.
For what? Other side is not.
My lords,
20
I've
30th
intimated, my
Jan.
lords, the intimation has been sent to the, I've placed on record the emails that have been sent to
But
the.
we go by endorsement on our board. Yes.
still
My
number
lords,
20,
one submission, my lords, for a moment, page number 29, my lords. For a moment, page number 29. In this Christmas vacation, my lords, it's a consent order. She has agreed, my lords, then coming to the Christmas vacation, mother along with the child shall come to Bangalore on 22/12/2024 till 25/12/2024.
So liberty to move the vacation judge.
My lords, let her comply with the order, my lords. I'm ready to bear the expenses as per the consent order.
There is no service so far. So if you want liberty, you may proceed. Otherwise, it will go to 30th January.
Liberty.
Liberty is reserved to move the learned vacation judge upon the petitioner satisfying about the urgency. Upon the petitioner satisfying the learned vacation judge about the urgency in the matter. Yes.
still number 26, to Sachin BS,
The officers raised an objection with regard to the maintainability of a writ appeal. I have challenged the order of the single judge along with an order passed in a review petition. Yes, there is a division bench judgment of the Madhya Pradesh High Court saying that a single appeal challenging the single judge order as well as the review order is maintainable.
Notice returnable on 30th January.
Office objection be overruled.
Office objections overruled. Maybe complied with before the next.
Office objection raised is with regard to the maintainability of writ appeal.
Except about the maintenance appeal, which shall be considered by the court.
It appears the respondent is be
I have
directed.
responded, my lord, accepting the notice, my lord.
Honored advocate, Mrs. So-and-so, so-and-so.
Then GA, my lord.
So-and-so, so-and-so accepts notice.
Fix the date, my lord, January first week, my lord. Fix the date, my lord.
Date is already fixed. In all matters, here date is fixed.
Is
Give some.
still number 27.
Here, January.
My lord, appear for the appellant in this, my lord. 2 weeks' time may kindly be granted, my lord.
Pardon?
I will comply with the office objections.
Which one? So within 3 weeks, you may comply.
Much obliged.
In 3 weeks, the office will be complied.
Yes, my lord.
That's all, in 27.
28 to 38 are urgent. Still number 39 is a fixed objection along with council submission. 39.
This case, notice may be only issued to respondent number 3, because respondent number 1 and 2 were.
Notice to respond 3. The office objections are for the time being kept in abeyance.
Serial number 35, my lord. There is a connected matter, my lord, writ appeal 276 of 24. It may be posted along with that matter, my lord. Both are, my lord, the same.
Here, all 3 weeks are already granted, 4 weeks are already granted.
It is posted, my lord, 7/1. This may be tagged on to that.
You file a memo before, after vacation,
Please, my lord, 276 of 2024.
on that day, not now.
Number 40.
My lords, 31, one submission, my lords. First, the office objection is only with respect to government has not been served. I may be permitted to delete first respondent.
Which
government.
one?
Serial number 31, my lords.
There are 3 office objections.
You remove whatever you want to.
My lord, with regard to serial number 28, it's a contempt. My lord, my submission is the contempt is not maintainable. If your lordship could just look into that,
On that day, when that is.
Please.
Number
All our office objections have gone. Yes, next,
number
41,
40.
40.
40. Mr. Srinivas TP.
Nobody is there. 20th February.
Number 41. Mr. Basuraj Patel GK.
23rd February. 24th February, sorry.
Still number 42. To Venkatesh S. Sarbati.
There is a delay of 674 days in this case. my lord.
Translation.
There is a delay of 674 days in this case.
Delay
Yes, my lord.
in 42, writ appeal, notice returnable on. Pardon? So notice returnable on 3rd March. For the time being, the office objections are dispensed with. However, if the court requires at the subsequent stage, the appellants shall have to comply with the office.
Number 43. To BP Negre.
I pay for appellants, my lordship. My lordship, the council submission is the typed copy I have already furnished.
Type copy. Learned advocate states that the type copy is already furnished, therefore.
And it will be overruled, my
Right
lordship.
with official verify the compliance and then list the appeal for admission hearing after
There
vacation.
is delay, my lordship.
Okay, then don't write. Learned advocate Mr. So-and-so states that the official decision regarding legible copies, public type copies are complied with. In that view, there shall be notice in the IA for contingent delay, returnable on 3rd March, 4th March.
Grateful.
Your submission. Serial number 41. Serial number 41. I end up in the court on 2.
41 is what? What is it about?
41 notice. Notice me, my lord.
Notice for what? All right, notice.
Please.
Notice is on 19th February.
Only the direction is issued to the respondent number 2.
Before the next day, the office objection will be complied.
Please.
Please choose. It's a pronouncement of judgment and order. Seal number 1, writ petition 5330 of 2023. The G.R. Mohan.
The Gandhi Bazaar petition is dismissed. We have noted everything about this and said that
Seal number 2, it's a writ appeal 949 of 2023 to A.T. Malya.
949 appeal is dismissed.
Seal number 3, it's a writ appeal 254 of 2024.
Respondent.
Shrikant.
Appellant by me, my lords.
It is held that section 16 of the Act can be invoked only by the senior citizens or a parent. Right of appeal under section 16 of the Act is not available to any other party. In the light of the above reasons, the appeal is allowed in part. The order of the learned single judge is set aside to the extent mentioned. Accordingly, writ appeal is disposed of.
But kindly liberty, my lord, to approach the writ court.
There is no liberty. What liberty?
But it is now that, my lord, now I'm in a precarious situation because now, my lord, since my petition before the deputy commissioner, my lord, my appeal before the deputy commissioner is not maintainable. Now my only remedy would be to approach the learned single judge, my lord, by filing writ petition.
He can appear before civil court also, my lord.
Seal number 4, the contempt 92 of 2024.
Sorry, my lord, I was not present yesterday. Serial
We
number
were
4.
waiting for you only. So little bit detailed judgment, but we have concluded that it is not possible to hold them guilty of contempt.
Yes.
So as such contempt it is not entertained, but we have noted your stand
Grateful,
and recorded certain findings. That's all.
grateful.
So then you look into it and then whatever you want to do, you do.
Small submission. But I would be left remediless, my lord.
What remedy?
But liberty to approach the learned single judgment.
This you will get after 2-3 days.
Fact in 6.
Yes, my only remedy, my lord, would be.
So you argued well.
Writ court.
You argued well, madam, but
My lord.
it was not well.
With my lord's permission, I am B.S. Manjunath appearing in this case.
So we have held that it is not possible.
No, I was only telling, she is my daughter, and it's been an absolute pleasure that such an encouragement has been received from some. I place my gratitude.
We do to all.
We have grown, it's been our bread and butter, we have grown.
Wherever I find that somebody argues well, I do
Yes,
tell
no, it's a family where such encouragement gives such a big impetus for us to go.
So result is not material.
The result is not.
Where the one argues.
Definitely, my lord. Result is not material.
The background of things that's going on.
India is one.
Gives such an impetus individually for.
Thank you, Vani. Thank you very much.
Much obliged.
Is seal number 5, the writ appeal 831 of 2024.
For the appellant.
Appeal is dismissed.
Appeal dismissed.
We wish your lordship happy winter vacation.
Thank you. All of you too.
Yes.